My name is Alex Lohman, and along with my colleagues, Ms. Naz Matt and Mr. Andrew Baytog, we are here to present our Superpowers of Special Litigation, what we do for our most vulnerable youth in the dependency system. So, at the outset, who are we? We are the Juvenile Advocacy Project. As our supervisors like to tell us, we are the dependency specialists. So, we come from the Legal Aid Society of Palm Beach County. In our Legal Aid Society, we have two different projects that really address children in licensed care. Our first project is the Foster Children's Project. They represent any child coming into licensed care 0 through 12, and so they take a lot of cases. Our project, the Juvenile Advocacy Project, we are court appointed, which means either the judge, sua sponte, or a party to the litigation has seen some exceptional need that warrants the appointment of an attorney ad litem. So we don't really have like concrete or set criteria. We have some most common criteria that we see coming in. So for example, a judge might see a documented history of mental health issues. There might be severe substance abuse allegations, severe trauma in the child's history or past. We're seeing a lot of human trafficking right now. So a lot of exceptional needs that are jumping out on the page that say, hey, this child needs a little bit more guidance and protection from an attorney ad litem. So as the slide mentions, the majority of our clients are emotionally, developmentally, or physically challenged. And so with that, we have a core philosophy. Our superpower really is holistic representation, but within that, the root of it really is be the anchor, be consistent, be trusted. As most of us involved in the system know, it's in constant fluctuation. We have DCF attorneys changing, case managers changing, school placements bouncing around, home placements, foster placements continuously changing. So if you can be that one constant anchor to the child, you're really going to really develop a great relationship and be able to advocate for what your client really needs. So kind of touching on that, our core philosophies are holistic representation. So when we're getting a case, a judge might say, Ms. Lohman, there's a documented mental health history here. We're going to ask for your project to be appointed, and we'll accept that appointment. But when we really dig into these issues, we realize that it's not just mental health. There's about 5 to 10 different things going on in this kid's life. So I like to analogize it as you're kind of getting a wound at its worst, and there's a lot of swelling, and you got to take away the swelling to really figure out what's the root issue going on here. So legal representation for our clients is multifaceted. You might have education issues. You might have family instability. You might have school accommodations that are not being met, that are contributing to what is being presented as a mental health problem. So teasing that all apart means we're going to try to be anywhere and everywhere that the courts will let us, the schools will let us. We're going to try and be wherever our client needs us to be. Our objective in the courtroom is really to be in charge of all the information related to our client. And really that plays a big role when we're talking about juvenile as a whole. So we have delinquency and we have dependency. And so in that sense, we have two systems that for our clients, our minor clients, really need to be talking more to each other, because what's happening in one is really impacting the client in another forum. And so being that attorney who can be in both courts and systems really helps us fill that gap and that lack of communication that's going on between those two systems. So we want to have all that information, share it as needed, so when we come to the table and we come with a creative solution to what we've identified as the problem, we've gained kind of the support and the backing of the other parties to both cases. So touching on that, our main areas of representation, dependency, delinquency, a lot of education, family. I included traffic because recently I was appointed to a 13-year-old who got a traffic citation for going for a little joyride. So that does happen. Traffic court is a mess, but it's very fun. We also do probate, and we're in the administrative courts a lot for our education cases, and we do our own appeals in our project. So hopefully we're making good case law for our clients. So our objectives. Didn't want to come up here and just say, this is what we do, we're great, without giving you a little support of the efficiency and efficacy of what we're doing. So these are our best practices, and we measure them annually. And when we're measuring them, we represent about 250 kids a year on our caseload divided by 6 attorneys, a social worker, and 2 very, very amazing paralegals who help us get through every day. So first, our first best practice is that 93% of dependent children will not have verified maltreatment reports while receiving our services and representation. And last year we met that with a 97.7 success rate. Our second objective is that 85% of children who are referred to us for that exceptional need that was identified at the outset will receive our services and will receive advocacy for those needs. So we met that last year with a 98.9% success rate, but as we were building this presentation, we were asking, why is that not 100%? And the best way I can kind of give you context to that statistic is life. Sometimes the kid will come in, we'll get an appointment, and that kid will run. And that kid will be on run for longer than a month. And with our caseload and the demand, we kind of have to assess what we can actually do for a child on run that long. So we might have to discharge off of that case so we can take another case for a client who needs us. Additionally, sometimes we have jurisdictional issues. We might be appointed to a child who's coming into the delinquency system on a violation of probation, and it turns out the underlying charge is in Broward County, and we're in Palm Beach County. So jurisdiction will transfer, and unfortunately, we can't go with the kid. We wish we could, but we don't have authority in Broward County. Third, 70% of our delinquent and dependent children are not arrested or incarcerated while in the program for at least 6 months. I'll be candid, this one's really hard. Given the vulnerable state of our clients, our at-risk youth, given the nature of kind of our group homes and quality of mental health control, our kids are getting picked up quite frequently. But also, to give a little bit more context to this, more often than not, when we're getting appointed to these cases, we're getting into them right at the height of whatever crisis is happening. So it's just on the verge of exploding. So we need time to get in to kind of piece apart what's going on, assess what legal strategies we can implement and what social services we can put in place. So we're having a little bit of a lag time catching up to what's happening. So hopefully when we finally catch up to where the child is and really get those services in place, that statistic goes down. But that is a difficult statistic that we work tirelessly on to meet every single year. And our last best practice is that 75% of youth age 18 or older will not be arrested within 12 months of case completion. And last year we met that with an 80% success rate. So I could talk about the Legal Aid Society all day long. I think I have the best job in the world. But the best way to really assess what we do and work through it is to give you a case study. So the three of us put our heads together to kind of assess what are the common things we're seeing with our clients, what are the most difficult things we're seeing with our clients, and how are we tackling that in the courtroom. So for our case study, our objectives are identifying the current and future needs of our clients, and how do we advocate for those needs, both in the community and in the courts. At the outset, we're not here to tell you how to diagnose mental health needs, what are the best psychological and psychiatric tools you can be using. We're not doctors. We wish we were. We're lawyers. So we're going to teach you how to advocate and really pull those resources together and get those experts together to really provide the best representation for your client. So in this case study, we have Jane Doe, very creative. She is 16 years old and she is a dual status youth, meaning she has both a dependency and a delinquency case in front of her. But first, our favorite thing ever, ethics. So I'm going to turn it over to Mr. Baytog to kind of walk you through some of the ethical considerations that we face on a daily basis.
Thank you. My name is Andrew Baytog. I'm also a staff attorney with Juvenile Advocacy Project. Before we get into the case study, I wanted to talk a little bit about some of the ethical rules that we encounter as attorneys for juveniles. And we're going to, as we go through the hypothetical, discuss some concrete examples of how these apply. But just real briefly to summarize a few of the ones we want to highlight. The first, one of the biggest ones that we'll encounter issues with is 4-1.14, client under a disability. All of our clients as minors are technically under a disability. But it's important to remember that the rule here requires that an attorney maintain a normal attorney-client relationship with the client to as much of an extent as is reasonably possible. So it's not a simple binary analysis of whether a client is disabled or not. Do we implement substitute judgment or not? But it's really important to keep in mind that it's a spectrum, and it's very context specific depending on the client and the situation. So when you have maybe on one extreme a client who's very young with profound disabilities, low IQ, non-communicative, that client may require a great deal of substitute judgment on the attorney's part. On the other hand, you may have an older teenager who is very bright and doesn't require any substitute judgment at all. The kind of ethically thorny issues where you have that gray area in the middle where you have maybe clients with differing level of disabilities. Maybe they have, you have a kid maybe an APD with an 80 IQ. Where do you draw the line? And the key to this, resolving these issues, is by knowing your client. You've got to get out there and meet the kid. You have to deeply immerse yourself in the case to really understand where this client is going to have issues with capacity. And I think you tend to find that it's easier than you might think to honor the client's wishes. Because if you really get to know the client, you can see where their limitations are, and a lot of times even kids you might be tempted, if without understanding, to write off as not having capacity. You can get through to them. You can kind of reach a point where you understand what it is they want to do, what they're trying to accomplish, and how they are able to inform representation. So it's very important to keep that in mind, and we're going to run into, in the hypothetical example coming up, some kind of gray areas there. The next kind of three interact together as Rule 4-1.2, objectives and scope of representation. This basically goes to the proposition that an attorney representing the client dictates the goals of representation. The attorney is responsible for the means and legal strategy employed in representation. And this I tend to think of as more of a dialogue between the two. It's not simply the client setting the goals and the attorney just going out and doing it, but the client needs to be kept informed of how those tactics affect the circumstances, how those change and evolve over the course of representation. But generally the standard here is that the client's determining the goals and the attorney is determining the means. And this is bounded by the Rule 4-3.1 regarding meritorious claims and contentions. So this is something we encounter a lot, I think, in our department from the outside. People tend to think that we represent children, they must have a lot of frivolous and irrational goals that they want to pursue, and how do you represent kids who are so unreasonable? I can tell you that first of all, we have this rule: as an attorney, you simply cannot ethically argue for something in bad faith. You have to have a meritorious legal argument in order to go out there and advocate on behalf of a client. You can't just do something that is frivolous. But I can tell you that I came to juvenile from a previous career in consumer law, and representing adults. Just the contrast is to me. I often see this being more an issue with adults than I have with juveniles. Juveniles tend to be more deferential towards your role as an attorney, and they tend to take your advice maybe even more so than a lot of adults do. I can't even tell you how many times I've run into adults who will just sort of sit there with the most outlandish and unreasonable goals and just sort of argue with you when you're trying to give them legal advice. So it's not really as much of an issue as people think, and you might have a kid who wants to do something that is outrageous, but and this goes into the next rule we're going to discuss. When you sit down with that kid and you explain to them, hey, this is too far, I cannot legally argue this, they tend to take that and process it pretty well. And again, that goes back to deeply knowing your client. And that's one of the things I think we do really well at Juvenile Advocacy Project is, we're always out there meeting with the kids. When we're not in court, we're usually out on the road meeting them at the placements or at the mental health hospitals or the detention center, and getting to know them and developing that rapport with them so that we really do have that level of trust where if they want to do something that maybe is impossible or meritless, we can sit down with them and advise them to the contrary, and a lot of times they do take that advice. And so that goes to Rule 4-2.1, the role of the attorney as advisor. So it's important to understand your job representing the juvenile is twofold. You are an advocate, but you're also a counselor. And this is the one, doesn't get a lot of attention because it's generally behind closed doors. You're sitting down with the client one-on-one, privately advising them about the strengths and weaknesses of their case, about the limitations of what they're trying to achieve, and how it what they want might be kind of wrong-headed. So this is where you have those kind of private conversations with them as attorney to client, just like you might with an adult or a corporate entity. And it's very important, and maybe even more important than the role as an advocate, to give them sound legal advice about what they can expect. And this will actually, it's interesting, it goes beyond simple legal advice and includes moral, economic, social, and political factors that may impact the case. So it's important to give the client a whole picture of what they're trying to do and how that's going to affect them as best as you can predict. And this is something else that is going to come up a lot, I think, in the hypothetical. So with that, I'll turn it back over to Alex to introduce Jane Doe.
And I forgot to mention at the outset, on our slides in the lower right-hand corner for me, left for you, it labels the paragraph that corresponds to the handout you gave. We kind of decided that the worst PowerPoint presentations have like essays on slides, and no one wants to read that. So we wanted to break it up for you a little bit, so that's why we have those handouts for you. And they also have some good practice tips included, so you can take it away, make notes, whatever you'd like to do. So with that, before we jump into Jane Doe, kind of wanted to explain at the outset what we're doing. What are our two primary goals when we're getting a case? First, as Andrew emphasized, is really building that relationship. We are grant funded, and our funders require that we make contact with our client within 14 days of receiving a case. More often than not, we don't have a problem with that. What usually happens is we're in court on one case, and the judge will kind of be like, okay, we need juvenile advocacy on this project. Who's here from them? And one of us will be there and stand up and grab the appointment. And if the client's sitting right there, what's really critical for us is to make contact right then and there. Hi, my name's Alex. It happens a lot in our delinquency cases is where we're really initially getting contact. So the client will be sitting there. My name's Alex. You have a public defender. Your public defender is going to handle your criminal case more often than not. I'm working pretty closely with your public defender, but I'm your life lawyer. That's kind of what I like to describe my role as. I'm going to walk you through your education problems. What's going on with home? We're going to figure that out. Do you need to go to the doctor? Basic stuff that a lot of our kids are not getting. That's what we're here for. And I also like to tell my kids two things when I meet them, and I think this is very important at the outset. One, you are the boss lady or the boss man. You tell me what to do. I'm going to, navigate that, as Andrew explained, with the best tools that I have. But you got to tell me what to do, and that's part of building that trust with your client. Second, I always kind of explain going to court like a game of Battleship. I need to know where the other ships are. I need to know where the good information is and where the bad information is. And if you're going to tell me that, I can steer us to a good resolution. Most of my kids appreciate that analogy, so I keep that one going. On the second end of things, information gathering. More often than not, we're getting these cases right in the middle or towards the end when our client's facing sentencing, which is kind of difficult for us to work a case, but it happens a lot. And so we need to figure out what's happened before we got on this case. So we're getting all the dependency and delinquency records from the clerk of court. We're contacting DCF, our local CLS attorney, or our community-based care provider. We want placement history. Placement history tells us a lot about clients. How many times have they disrupted? How many times have they been bounced around? That might tell us a little bit about situational trauma, things we need to address. Are they in a structured therapeutic group home or specialized therapeutic group home? That tells us, okay, we've got a mental health need right then and there that we need to investigate. School records are also very relevant because in theory that should be our client's full-time job. More often than not, we have a problem with truancy with our clients. But they're there a lot, so we can learn their behavior patterns. We can learn if they're getting accommodations in school. We can learn about truancy if they need tutoring, a lot of stuff. Kind of like a prudent parent standard. When your kid's in school, what do you want to know about your kid and what they're doing? And last, birth certificate. For those of us who practice dependency, sometimes the birth certificate can be the best resource for answers. Who is legal father? Who is legal mother? Where was the child born? Because that might also tip us off to any immigration issues our client might have too. So with this information, where should we start? So with our dual status youth with Jane, We're working with two systems, delinquency and dependency. So on the delinquency outset, because we're getting appointed at the delinquency phase, we're at a detention hearing. The judge has jumped up and said, Juvenile Advocacy Project, we need you, Jane Doe. Here's where we go. So in the delinquency case, first we want to start off, what's our kid's detention status? If there's a good faith argument for release, who's picking up the kid? That seems like such a basic question, but that is often one of our most biggest challenges in delinquency cases. We need to contact the case manager. If you know who the case manager is, that's why a separate tenet of our practice is to really have good relationships with everyone in our community. So I can text someone at CLS and be like, hey, I just got this case. Can you tell me who the dependency case manager is? Helps a lot. So keeping those good relationships alive. Figuring out who the case manager is. If not, figuring out placement. Will one of them come pick up the kid if they're released? Seems basic, but it's often a very difficult problem we face. Determine the nature of the charges. Get those records at that information gathering outset. We learn a lot from probable cause affidavits, police reports. A child might have been Baker acted during the arrest, okay, so we have a mental health concern. There was aggression, maybe there's an anger management component we could be thinking about. So really dissecting those reports that we get in. On the dependency end of things, determine the last placement. Sometimes when a kid gets arrested, a placement will go, okay, no, we're not going to deal with you anymore. Kid's not coming back. So we have to contact our CBC and say, hey, we need to find a new placement. We need to find it now. So with that, again, contacting your dependency case manager, your DCM, or contacting your local CBC to figure out that information. This also seems very basic, but it's very important. Figure out the next date and time of the next dependency hearing. Make sure you're there. Make sure you get appointed on that case if your jurisdiction operates that you are court appointed. And get that information in the interim, because more often than not, our services on the dependency side of things are really going to help our kids in the delinquency system. So making sure you're in both entities is really critical. So page 3 on your handout kind of gets us started into Jane Doe. Who is Jane Doe and what can we help her do? We know that Jane is 16 years old. She's a dual status youth, meaning she has contact with both systems, or she has cases with both systems. We have been appointed because a public defender has said, hey, judge, this kid runs a lot. And this kid is exhibiting behaviors that make me think there might be a human trafficking issue going on here. We need extra help. Can the Juvenile Advocacy Project get appointed? So that is the main basis for our appointment. We learned that the underlying charge is a grand theft auto from the records you've obtained. Jane took placement van, and I'll also note that a lot of these facts are stuff that we deal with on a daily basis. It wasn't hard for us to come up with this. So our Jane took the van, went to go visit her mom, and so they charged her with grand theft auto. We're getting appointed on a violation of probation because Jane absconds from placement all the time. She violates the curfew that's outlined in her probation, and she tells you, I just want to go see my mom. So that's what we know. She's dual status. We also learned for her that she's having some unsupervised contact with mom. So mom is participating in the case plan in the sense that she comes to supervised visits and everything, but Jane tells you, oh yeah, I text with my mom, and we communicate on Facebook Messenger all the time. So those are the basics that we learn about Jane at the detention hearing. So in true Juvenile Advocacy Project fashion, normally what will happen is one of us is in court, we'll kind of field, we'll play, center field here. We'll field the case and throw it in to who the assigned attorney is going to be. We try very, very hard to make sure that whoever is making contact at the initial hearing is going to be the attorney on the case. Again, it's that consistency that we really want to try and develop. But sometimes caseloads are too high and you can't take that case. Or we do have some jurisdiction where NAS operates her caseload in our South County courthouse. And so if that's happening down in South County, it will go to NAS. So I always try and tell my kids, hey, listen, there's 6 of us. We work very closely together. Whoever gets your case is going to know everything that I know. I'm going to try and get this case, but sometimes I might not be able to. So in that fashion, I'm going to kick it over to NAS because we've determined it's a South County case and it's in NAS's control.
Hey everyone, as Alex said that I operate from another division and in a separate courtroom, so all the cases that come to South County Courthouse in Palm Beach County, I get them. So before we start, obviously you can hear that I have an accent. If I go too fast, let me know. I'll slow down. It happens sometimes. So I take over the case from Alex, and then I have to investigate a little bit more, because what am I going to do from now on? Is she going to remain on probation? Is she going to be possibly committed? Is the placement okay placement for her or not? Since she is constantly on the run, I don't know the answer to that. Meanwhile, what I start with is, as soon as I take over the case, I try to get all the records ready and reviewed, and I contact with the caseworker, I contact with the DCF attorney, I contact with the public defender and state attorney's office, and I also try to, I also try to visit the client, although my coworker just told the client she doesn't know who I am, so I would try not to bring myself to a point where like she has no idea who I am, but like I'm just talking on her behalf in the hearing. If I cannot see her between the hearings, I'll make sure that if she's in the holding cell, I go in, I talk to her, I introduce myself, I go over the confidentiality requirements, I go over explaining what my role is in her life, so I know what she's gonna say. And even 3 days can make a difference on what she wants out of the proceedings. As you might know, if you're representing children, they do tend to change their minds. It's not uncommon at all. So I try to do all of that between the time of the detention hearing and the next court hearing before the assigned judge. I have to just point it out, in Palm Beach County, every day at 1:30, we have detention hearings and we have shelter hearings. So oftentimes we have a client in the detention docket or shelter docket, or we're just in the courthouse just to wait for our hearing. So that's when we get appointed a lot, and whoever is there is just handles. And our dependents and delinquency judges are the same. We don't have, I know that that's the case in some counties, but all the hearings, if it's a crossover case, it goes to the same judge. We don't go and see separate judges for that purpose. So especially for me, if the detention judge is going to be different, but then the case will come to my division, and then that judge will hear the adjudicatory hearing, both for dependency and delinquency, and he's going to sentence. I think it also helps for the child to familiarize herself or himself with the judge. I think it's a good method. So these are the basic questions I ask when I have the case in front of me, and I try to find as much as information on the, in my mind, might be the most urgent matters. So I need to know why the child was removed, because let's say if the child was removed because of human trafficking issues, for example, so I know that there's some kind of merit to what the allegations were, but if it's something else, then it might or might not happen. I don't know yet. How many placements that has she changed? Because the more, if the child has been through several placements, it kind of tells me that the child might be exhibiting some aggressive or destructive behavior, and basically none of the group homes wants to deal with her. And what's the current placement of the child, and can the child return back? Because sometimes the child, if the child is held in secure detention for so long, they decide to just submit a disruption notice and give that back to someone else. Sometimes it happens, so I kind of need to know where she can go anytime she's released. In order for my future references, I need to find out if there's any mental health issues, if there are any evaluations that can assist me with that, if there has been any Baker Acts, recent Baker Acts. If she's on any psychotropic medication or not, if she is she happy with the medication, and any other record that I might need. So also, because we got we got appointed to the case because there were some human trafficking allegations that was raised by the delinquency side of attorneys. I need to find out if the case management thinks that there's a human trafficking issue or not. If they ever attempt to place her in a human trafficking placement, or if they had like a red flag staffing. I don't know if you have the same thing or if it's called something different in your counties, but red flag staffing is usually held by community-based care agency, and then all the parties, case managers, their specialists, they come together and they discuss the behaviors the child exhibits, and they basically flag them in their system if there are issues with like sexual, like some sexual behaviors or human trafficking behaviors. And if your client is red flagged in the system, the placement will, it's going to affect the placement a lot, because once the child is flagged, it kind of limits where you can place that child a lot. A lot of placements will come back and say, when they make the referral for placement, they're going to say, you know what, like we don't have enough tools to deal with a kid who might be involved in human trafficking. So I think it's very important for me to know. So knowing what I know from the dependency side, my next goal is to, how do I use those sources in the delinquency case and come to a good solution in the delinquency case. So I think that's why JAP plays a role in the kids with the crossovers a lot, because it's not all the time that dependency side and the delinquency side actually communicate with each other. Sometimes they do, sometimes they don't. So we basically become the party that knows all about it from all the sides. So, and then we start the communication, we start working on how we can go from here. So when I review the files, that's what I see. The child was educated dependent. The mom consented about 4 months ago, so she's been in licensed care for 4 months. And the reason why she was removed from the mom's care was the domestic violence between the mom and the mom's boyfriend, and there were some substance abuse allegations as the mom. So mom agreed to do domestic violence classes, parenting classes, individual and family therapy, individual and family counseling. And also Jane was provided services for individual therapy and family therapy, but the mom mentioned that the child is out of control at the shelters and she cannot control her behavior, so a psychological and psychiatric was ordered at the time of the shelter. You can see this. So we also find out that after speaking with the caseworker that the child was corrected as recent as 2-3 weeks ago, one time from her placement, and there was another correct that happened shortly before that, and she was corrected from the school. And the reason why she was corrected was aggressive behaviors in both ways, and she was saying that she's going to hurt herself. There are no concerns on the case management side about the human trafficking that she's involved in human trafficking, or it never came up, so we don't have any red flag staffings. There was never an attempt to place the child in a human trafficking placement. And we get the birth certificate, and the birth certificate tells us that the child was born in Guatemala. There's no legal father listed in the birth certificate, which automatically it's a red flag for us to say, hey, this child might have immigration issues that we need to look into. Jay's school records indicate that the child, like these are the most items that we look at. Those are the questions we ask ourselves when we request the records and when we review the records. And we need to make sure if she gets accommodations under 504 plan, or if she gets the support under individualized education plan. If our client was born in another country, we need to make sure if she needs ESOL services, and if she gets the ESOL services. And in Palm Beach County, I think that part might not apply to your county, or might. We have like a therapeutic school, for example, where there's a lot of therapeutic support for the children. It's a lot smaller school setting. So has she been in one of those schools? It would tell us a lot. And we have some behavioral schools where they expelled from the schools for having too many discipline referrals, and they're submitted to alternative school system for behavioral issues, so has she been in one of those? And then does she need tutoring? How are her grades? So these are the things that we always look at. And when we get the records, we say that she got 3 Fs, 1 A, and 1 D, and then she was given out of school suspensions a few times, and she was also back corrected a few times that we already heard about. And it was like being aggressive toward the teacher, so we kind of start seeing a pattern of a little bit of aggressive behavior. So, as I said, these are the items we say, and there are some like notes from the teachers saying that she has some behavioral issues at school. And knowing that, we go forward with the crossover hearing. I don't know if your county has it, because I know that the crossover hearings are arranged in Palm Beach County through an administrative order. Which is basically a special docket day for each division, and then the judges make sure that all the parties that's involving the child is on the table before the judge, which includes both DCF side, dependency side, and the delinquency side. So DCF attorney is there, guardian ad litem attorney is there, the parents attorney is there, as well as the state attorney and public defender, probation officer. So this hearing is coming up for me because if a child is crossover child, that's the only time we hear the cases in Palm Beach County. So I need to prepare for that hearing. I need to know what the parties are planning to do regarding her. So in order to do that, I just have to do a few things to make sure that I know where I'm going at. So you might remember that our client said that when she runs, she goes to mom's house. So I need to confirm that, because if she is not being 100% truthful with me, it means that she's staying with some other people. And I reach out to mom's attorney either via email or before the hearing, and either with the mom's attorney or by getting the authorization from mom's attorney. I talk to mom about it, and mom says that yeah, like she's over at my apartment almost every day. And then the reasons, and I think it's in the fact pattern, but we didn't mention it, something that tipped the public defender off was her fresh manicure, because it costs money. So we have to find out if it was paid by a third party or if it was mom, as our client suggested. So mom confirms that it was our client's birthday gift, so she paid for the nails. So do we still have a human trafficking issue? We don't know yet, but at least this part of our client's story seems to confirm that it might not be in fact a human trafficking issue. Because as I stated, once the child is flagged in the system, it comes with a slew of problems, so why would I want to flag my client if human trafficking is not really an issue? We don't know yet, one way or another. So Jane discusses the plea deal and the consequences of her immigration case and all that kind of stuff with her public defender. We usually try not to butt in that pure criminal part of it. And then after speaking with the state attorney and the public defender and the probation officer, we get a feeling that the state or the Department of Juvenile Justice might actually go forward with committing her, because she's on the run all the time. One, as a result of that, one, she doesn't engage in services or the conditions of her probation. Two, because she's always on the run. They don't know where she is. And they might or might not think that there are human trafficking issues, but because she's a runaway, like it is in their mind, it's safer for her to be in the commitment program. So after that crossover hearing, they do a plea deal, and our client pleads guilty, and then the state attorney tells you, hey, I'm going to ask for predisposition report and staffing with a commitment manager present. So I don't know how familiar with you in the delinquency system, but let me just give you a little bit like very basic information. The state has 21 days from the date of the arrest to bring the case to a trial, unless you wait that 21 day, which is a speedy trial. And on the 21st day, they can offer a plea deal, we can go for the trial, and if the child is found guilty, then we have 15 days from that day to dispose the case. Disposition in that case is almost like a sentencing for adults. So judge sentences the child if the child is found guilty by the manner of trial or he or she pleads guilty. So once the state attorney asks for predisposition report and staffing with the commitment manager present, it usually tells us that it's very likely that they want to commit this child. So in order for that, we need to get ready to come up with something else, something a little bit more creative to see how are we going to avoid this. Because if the child goes to a DJJ commitment program, that's not what our client wants. She wants to be in the community as much as possible. She wants to see her mom. And then the Department of Juvenile Justice commitment programs might be anywhere in the state of Florida. It depends on bed availability. So we're trying to avoid that at this point. That's my goal. Avoid her from going to commitment program, and that's my most urgent task. So just for your information, in case you're not very familiar with the delinquency system, but I think as attorney ad litem, you should definitely know if you end up representing a client with delinquency charges. Predisposition report is a very comprehensive psychological evaluation that is done by licensed psychologists. And they include the mental health diagnosis, they include psychosocial issues, they interview with the probation officer, the mom, the child, they include the education records, and they end up making recommendations as to what the child should be or what the child's services should be. If you see a word saying that this child needs a highly structured environment, like they don't usually recommend commitment right away, but if you see highly structured environment or like a residential placement, so there are definitely red flags for you because they mean that DJJ is going to recommend commitment for this child. And in our case, the comprehensive evaluation recommends just that, because the child runs all the time and they feel that the child is suffering from some anxiety and some other mental health issues, so they think that the child can get those services from a commitment program. I don't know if any of you have ever been in a commitment program, if you visited someone, your client or someone else, but I would not want any of my clients to be committed. I mean, it happens, but I wouldn't want to send any of my clients in a commitment program. So staffing is a meeting, basically. As I said, it has two components: predisposition report, which includes the comprehensive evaluation, and we have a staffing where all parties come together, and as the outcome of that meeting, the Department of Juvenile Justice makes a recommendation for the court. So we always attend those meetings. I think it's very important to let the Department of Juvenile Justice and the attorneys and juvenile probation officer to know what our plan is going to be. What are we going to come up with? And that's why we get appointed to come up with something in that one. So, and most importantly, again, we need to go back to our client and we need to explain to her if we started getting, the comprehensive evaluation, which suggests a structured environment, and you talk to the state attorney, and state attorney oftentimes tell you, hey, I'm just going to argue for commitment. So you definitely need to speak with your client about it. You need to let her know, hey, at this point, probation might not be an issue, or probation in the community might not be an issue, but hey, we have your Baker Acts, we have other anger issues and things like that we have been seeing. So I'm just going to go ahead and request a suitability assessment and see if they're going to recommend a higher level of care for you, if that's what you need. And in that situation, you think that your client will say, yeah, I'm just going to go to another lockdown facility. No, they're not going to say that. They will say that I have no interest in going to anywhere. Like, I just want to go back to my mom, or I want to go back to my foster home. But I feel like as the attorneys of the child, we need to make sure that it is ready for our client if she changes her mind. I mean, how often does it happen? It happens a lot. Although at that point of the game, your client might just say, you know what, I have zero interest doing it. we still need to make sure that it is ready for use in a way when needed.
So I'm going to jump in real quick here because I forgot to mention the orange bullet points on here are kind of our ethical situations that we flagged to discuss. We did apply for ethics credits, so if you're in attendance, you'll receive some ethics credits, so yay. So with that, I'm actually going to pass it over to Mr. Baytog to kind of discuss this ethical issue that's coming up in our representation of Jane.
Everybody's favorite subject, I guess, right? So it was, at this point, I think it raises a lot of interesting ethical issues. When we see this in practice quite a bit, I think with our clients, where we're at a disposition and the Department of Juvenile Justice is recommending commitment, and we have maybe a suitability that's recommending step up to an RTC, and a client who doesn't want to do any of that. Part of that is understanding the client's situation, and you may be tempted to look at 4-1.14 and see, is this a situation where substitute judgment is warranted? But I can tell you that in practice, that's very rare, and a client like Jane is generally not going to be the kind of situation where you would want to implement substitute judgment. Instead, the way to approach this kind of thing from an ethical perspective is to keep in mind the role of advisor, to have that conversation with the client and outline the various options that are before her in a really matter-of-fact kind of way. Explain what's likely to happen, what's not likely to happen, and keeping in mind the meritorious claims and contentions rule, 4-3.1. You can't just go out there and argue for emancipation for Jane. It's just not. It's a frivolous argument. So you can't go out there and make ridiculous arguments. Explain that to Jane, that you can't. You're obligated as an officer of the court not to just go out there and say something that is legally unsupported. Could you argue for her to go back to her old group home rather than the RTC? I mean, you could probably come up with a colorable legal argument for that, but it's highly unlikely to succeed, and that's something else that you need to explain to Jane. These are the weaknesses of your position here, and with all of that into consideration, you've got essentially a choice between a commitment program and the RTC. And having that kind of fork in the road, a lot of times the clients will understand, really only have two options in practice. So having that conversation as the advisor will resolve a lot of these ethical issues that you might encounter. So I think the tendency should be, keeping in mind the rules, diffuse these situations with advice rather than just trying to countermand the client with substitute judgment. And frankly, you have a happier client that way. I think you have a client that if you've at that point established trust with them, that you've got that rapport with them, they'll take your advice, or at least to some extent. It doesn't mean you can necessarily get through to every client every time, but you have that conversation, they feel listened to, and maybe they take some, if not all, of your advice, and you can kind of devise a strategy that takes into consideration both the realities and your client's desires. So, and it all depends on the kid. So it's a spectrum. There's really no black and white here. There's no bright line. You really just have to know your kid, and you have to know your obligations.
So where we left off was, I informed my client that I will be asking for a suitability assessment just in case. And the way we do it in Palm Beach County, I just put that disclaimer out there in case your procedure is a little bit different. We go to our community-based care agency and we inform that we would like to have a meeting about it. And after the meeting, oftentimes or not, they just start requesting a suitability assessment. As the attorney ad litem, you can definitely reach out to the assessor in case the assessor does not have all the information and share what you know about the case. Of course, you have to take into consideration of all the confidentiality, like for example, if it's a confidential information, obviously you should not be disclosing it without your client's consent, but anything that is out there is a common knowledge, then you can definitely call the assessor and let him or her know about what you know. They might or might not have information, so I always try to reach out to the assessor when we have a suitability assessment. So in our case, the suitability assessment comes up with RTC, Residential Treatment Center, and we have a few residential treatment centers, one in Palm Beach County, that we work pretty closely in general. So I always make it a habit of reaching out to them even before the placement or the community-based care agency sends out the referrals to all sick placement in the state of Florida. I inform them that, hey, I'm on the case. Hey, can we keep the kid here in the county, because it's going to be practical for me for visitation standpoint, just not only my visitation, but also my client's visitation with her siblings and with her mom. And then they say yes sometimes, or they might say no. But I try to spin everything to my client's advantage. And then I definitely reach out to the delinquency side attorneys, and I inform them, hey, we have this recommendation, and then we can resolve this delinquency case or delinquency plea based on this alternative option. And most importantly, we have to have this very long and serious conversation with our client to say, hey, we don't know what the judge will order. I don't know if judge will continue on probation or if the judge will commit you, but it sounds like at this point, both the DJJ, Department of Juvenile Justice, and the state attorney is going forward with commitment. So in order for us to not risk it, we have this option. So are you willing to take this option, or you just want to go to disposition hearing and just take your chances? And let me tell you, I think based on everything that's been going on, I mean, at this Palm Beach County, a lot of times if the child runs a lot, like a lot of judges decide not to take chances, not to take risks in case something happens to that child. So it looks like the commitment is coming. And then after speaking with that, and the visitation might be easier because she would be in county, and then she would get the services. So our client ends up deciding to go with the RTC route, and then Andrew will talk a little bit more about it, how we approach it on the ethical standard.
Yeah, so I guess just a few practice pointers on how to implement this, because again, it is a very common dilemma, and it's kind of illustrative of how to address these situations where what the client wants is maybe outside of the realm of possibility, but you do have options nonetheless. Is to it's all in how you present it. You know, you're having in your role as an advisor, you're having a negotiation with your own client. You know, you're talking with them about their wants and needs, and they may say, oh, I want to go back to my old group home. I don't want to go to this RTC place. I don't want to be locked up anywhere. You know, so DJJ, RTC, they don't want to do either of those things. It's helpful to explain, you know, what the realities of the situation are, but, you know, listen, no judge is going to let you go back to that group home. You've got these two real options, and then at the same time present some of the positives. You know, so this goes back to 4-2.1, where you take into account not just a bare legal analysis, but also they say the moral, economic, social, political, but also quality of life factors that are at play here. You know, one of the big selling points just is an RTC we have down in Palm Beach County with a pool. You know, it's just nicer. Yeah, so a lot of times you can sell the clients on these good ideas, on this good legal advice by focusing more on their concerns, their quality of life issues. And you get that from knowing the client. I keep going back to this because this is really how you resolve these ethical quandaries that you might run into as a juvenile attorney, is you know your client, you understand what their limitations are, what their level of comprehension is, what their wants and needs are, what their goals are. And the more you understand that, the more you're able to develop a strategy of representation, both as an advocate and as a counselor, to get them to where they need to be. So hopefully you can reason with this client, with Jane, you know, to make her see the wisdom of advocating for the RTC. And you know, you don't want to waste an argument on something that's just not going to be successful at the expense of losing out on this RTC option at the disposition hearing. Some clients are just, you know, set in stone, but they don't want to, you know, be locked up. You know, it happens. So maybe in those kind of situations, you want to compromise. You know, so maybe, okay, well, you don't want to go to an RTC, but maybe we look at offering a proposed solution of outpatient services through your current placement or something like that. You know, it may not be likely to succeed, and you have an obligation as an advisor to tell your client that, you know, listen, I don't think your goal is realistic, but here's some alternatives that we could try. If you really are that sure you want to go that route, but it's costing you this. We're going to make this argument if that's what you really want, but it's not likely to succeed. And if we fail on that strategy, then you're probably going to be on that DJJ program that's so dreary and depressing. So having that conversation and framing it the right way, I think is key. And again, it's not just the way you represent juveniles, but it's the way you represent every client. You take these same principles as you would representing, a corporation. You're talking to the corporate representative about what you're going to do for your corporate client. You have the same sort of considerations in principle. It's all in how you frame it, and when you get somebody that has maybe an unrealistic idea, you have to sort of diplomatically explain how it's not realistic and give them alternatives.
I'll also note that Mr. Vatog said that so eloquently, but if you have a bird's eye into some of our conversations with our clients, it's a little more blunt than that. Our kids are not really into the flowery language. It's more, listen, kid, here are your two options, and we go from there.
Okay, so having this in our back pocket, we attend the disposition hearing. So right now what we have, DJJ recommended commitment, state attorney wants commitment, and we have a suitability assessment, which requires a higher level of placement than regular group home. So our offer is going to be, when we go to disposition hearing, is to place the child on probation, but include a special condition as a part of the probation for the child to successfully complete the RTC. And then maybe when she completes the RTC, then her probation will be terminated successfully, especially since if she will complete all the other recommendation of her probation conditions. Okay, so we do the disposition and judge grants it, so the child is placed on probation. And the judge said that, is the bed available today? Yes, it is, because we know that, because we have been figuring that out with the RTC and the case management, I'm sorry. And so the child is released to caseworker that day in court, and here she goes to residential treatment center, which is in the county, and the adjudication is withheld, which is another important outcome. So although kids and although the parents that we work with think that nothing is going to show up in their background because they're minors, no, they do show up. And adjudication being withheld versus the child adjudicated delinquent will have different effects in their background as well in the future when they start working at a field where very intensive background checks might be required, so it comes up. I actually have a client, and she pled guilty to just a regular battery charge against her grandmother, which it was a result of a lot of family situations, but right now she's in college and she's working at Walmart, and then she applied to Walmart. Her battery charge came up at the background check, and she's trying to now expunge and seal it, but you can do expunge and seal only if allowed by the statute. So it's still, I think the education being withheld versus the child being adjudicated delinquent makes a big difference in the future in their lives. So during that time, what do we do? Now that we took care of the emergency, so what do we go? Of course, we don't just close the case because we resolved the delinquency case and the child is in RTC now. We make sure that we attend the treatment team, multi-treatment team meetings, and I know that all SEPs in state of Florida, as well as specialized therapeutic group homes, they arrange a call-in number. We always have a conference number, so no matter where the child is placed, although mostly we work with Palm Beach providers, if the child, let's say, in a specialized therapeutic group home in St. Augustine, we still call in and we still participate in those meetings. So we definitely keep in touch with our client. If she or he is prescribed psychotropic medication, is he or she happy with it? Does he or she report any side effects? Does she or he say that they don't want to take it? So sometimes we find out because our clients are minors, they're not effectively communicate those issues with their psychiatrists or the caseworkers. So if there's an issue with that, we definitely reach out to the placement and we discuss that with them. And then a lot of SIP placements, again, in this case, they have schooling in their own campus. The kids don't live anywhere, but and then most of the time the kids are in hospital homebound and they get an IEP as a result of that. But throughout the time and after, like when we get ready for the child to step out, we need to make sure we get together, we have a school meeting, like let's say, what is their recommendation when the child is stepped down? Do they recommend an IEP? Do they recommend a specific school that is behavioral in nature or therapeutic in nature? Do they recommend like a specific public school? Because if the child has an IEP or about to have an IEP, we can switch schools throughout the choice program. So we definitely need to keep that in consideration. So now that the urgency has left, we definitely need to look into the immigration issue. Luckily, in legal aid, we have an in-house attorney that deals with the immigration issues of our clients. So we don't have to go far, and it has been very practical, but we have had her only for a year or so. So in the past, if we did need an attorney for immigration purposes, we would try to find a pro bono attorney either in Palm Beach County or if the child is in another county, because then they have to go to that USCIS of that area. We had to find an attorney, let's say in Orange County, that would take the case pro bono and then work on the immigration issues. So SIJ, special immigrant status, special immigrant juvenile status might be an available relief for the kids who are in foster care. And even if your case plan is reunification, it does not because the father is not in the picture, and then the reunification with the father is not possible, she would still start all these reliefs. Like, we don't need to necessarily wait for the case plan to change from reunification to something else. But that's a topic that the immigration attorney would know so much better than I am. So we need to make sure that our client, Jane, continues to see her siblings, continues to see her mom. It's very important, especially if we have sibling groups in licensed care that are placed in separate placements. They have a legal right to see each other. So we need to make sure that it's being monitored and the siblings can visit with each other regularly. And then once the discharge time is coming up, we definitely need to come up with a plan. Where does she gonna go? Is she going to go to a specialized therapeutic group home after a residential treatment center, or are they recommending step down to a regular group home? If a regular group home, which group home in Palm Beach County or in the surrounding area is the best fit for our client? We definitely reach out to the placements ourselves, although it is technically the case management's job. We take that into our own hands. We make sure that everything is arranged way before the child is discharged. I mean, does it work like that all the time? No, but we do our best. And then after that, once the child is released, now we are going to go back to Mr. Beta for the last portion of our example.
Yeah, so this is fast forwarding to Jane, now 18, approaching aging out of foster care, and in the hypothetical, we're imagining that she's now asking us to file a motion to reunify with her mother, who has at this point not been following the case plan. Really, there isn't any good reason to do this, except that Jane still very much feels bonded to her. And again, we frequently see this where kids who may not have a strong objective incentive to reunify still want to, because that familial bond is so strong with them. In general, this is one of the last steps we take in a case. We at Juvenile Advocacy Project only represent kids up until age 18. Sometimes we'll stay on a few weeks after that to kind of see them through the transition process. But for the most part, we conclude a case when the kid turns 18. So I think I would start the process early on and advise the kids about their options. There's 2 big programs that you really want to suggest to a client that is in the dependency system right away. Soon, depending on when we get the case, but generally when they start high school, you want to start them thinking about what they're going to be aging out into, if they're going to be aging out of licensed care, and those are the PES program and the extended foster care program. The ideal outcome, I think, for most cases is going to be a kid turning 18 out of the dependency system, diploma in hand, and qualifying for PES, because that's just one of the best and least restrictive independent living programs that we have. They get a check for $12.56 a month so long as they're in post-secondary education, and what is required is that they have a high school diploma or a GED or the equivalent. So not a lot of kids do make that goal by the time they turn 18. They can qualify for it after if they do end up getting the diploma some point after they turn 18, but for the most part, if they're still working on that, getting that diploma, then they're going to be in the extended foster care program, which requires that they participate in a qualifying activity. And if you attended the adulting seminar yesterday, there's a very good synopsis provided there about what all you need to qualify for extended foster care. So with Jane, we had the situation which we encounter frequently enough, where she's closing in on 18 and she's in licensed care, so she is set to qualify for one of these programs. If she hasn't got the diploma, then it'd be extended foster care, which is still great. I mean, they cover your rent. It's a great benefit and one of the silver linings about being in the dependency system. But she wants to be with her mother, even though it's going to cost her eligibility for these programs. This is where, again, getting back to the ethics rules, you want to go back to your considerations as counselor. Take the complete picture in mind and explain to Jane. I think it's best to have that conversation, in a heartfelt kind of way, understanding her commitment to her mother, her relationship with her family, and the importance of that, but also contrasting it with what she stands to lose if she is successful in trying to reunify, and what exactly the drawbacks are of that. So it's a tough conversation to have, and a lot of the times it can really go either way, because it's these kind of conversations come up. It's sort of a financial decision versus an emotional decision, and a lot of kids are really going into this eyes wide open and still making that decision to forego a lot of these benefits. It happens all the time, and while it may not be in a strict dollars and cents view in their best interest, I mean, it's very hard to have to take the position that their family is somehow less important. So as long as the kid has been fully advised, I think you're definitely fulfilling your ethical obligation there if you go forward on sort of advancing this argument for reunification, and even if you're able to prevail on it, I guess you were imagining it's kind of a weak argument, but as long as you've advised the client of all the drawbacks and this is still what she wants to do, then I'd say go forward with that. And sometimes it works out. It's not always necessarily a bad thing, even though it might kind of look on paper like it is. A lot of our great success stories kind of go that way, where we have kids who kind of reunify with families that you may not have ever thought were right for them, and they end up doing great. So a lot of it is just kind of trusting your client, and again, once you get to know them, you can kind of gauge where they are, where is that level of trust, and how strongly should you press in your role as advisor before you're kind of satisfied that they know what they're talking about. Go forward on that argument as advocate, and advocate for it as strongly as you can. One last thing I want to mention, I don't think I got to before, is practice pointer. When you're having these conversations with your juvenile client, as advisor, your obligation is to have a frank and kind of like Alex was saying, hey, look, kid, this is your. But part of it is making sure they understand that dual role, because a lot of times these kids they're having their experience with adults in positions of authority is being lectured to all the time. So here you are as advisor, a lot of kids are perceiving that as just another lecture. So it's really important, I think, to kind of bookend any kind of advice like this that's going against what they want with an explanation that I'm giving you this advice in my role as your counselor. I've got two jobs. My first job is to advise you, but then you're the boss, and I have to go out and advocate, within reason, what you want. So understand that even though I'm giving you advice now privately, in public, I'm going to go out there and argue for what you want as fiercely as any other lawyer is going to. So making sure the client understands that is, I really think, half the battle, because that builds that relationship of trust that allows them to understand where you're coming from and take your advice. So if you don't have that trust, this whole thing kind of falls apart. So with that, I'll give it back to Alex.
So that's kind of generally the life of one of our cases, and we wanted to walk you through kind of the evolution of our cases. As a concluding note, what I thought was interesting was when we were building this case model together, we all came to different conclusions on whether or not you should file the motion for reunification. And I think that goes to show, like, each of us has a unique perspective. We have experiences on different cases and clients that inform what we'll do next. So my gut reaction was, I wouldn't file. I don't think you have enough to show substantial compliance. Andrew was like, yeah, go right ahead. If she's engaging with the child and showing an emotional relationship, you have a compelling argument that, yes, mom may need a little bit more help. We can put in a targeted case manager. We can put in therapy in the home. But the best model for success for our client is having her mom. Sometimes foster care, we set up our kids maybe to flounder a little bit. And in that sense, if we want a child to be successful on probation, mom might be the best answer. And so we have to advocate through the dependency system for that. So I thought that was interesting. There were a couple of points where all of us were like, seriously? You would do that? But that's like our project, and we're very collaborative and we work together. And I think that's one of the great assets of our project is we all have different kind of expertise as we've gotten into contact with clients and different perspectives on moving forward legal strategies, and it makes us a really cohesive and great unit. So with that, we want to thank you. Thank you for coming. Thank you for engaging with us. We have a couple minutes left. If you want to come up and approach us with any questions, we really appreciate it. But thank you very much.